Hello, everyone, and welcome to today's facilitation session. We are still on our cooperative field admin course, CRD 322. So today we'll be talking about liquidation and dissolution. Last time we had a good time talking about a whole lot concerning liquidation as well, auditing, function of the cooperative assistance in this regard, and so on and so on. We talked about a whole lot in that particular session. So today, let me share my slides so we go straight to our topic, which is liquidation and dissolution. All right. Now, the intention of today's session is that at the end of today's session, every student should be able to discuss the concept liquidation and dissolution in cooperatives. Every student should be able to highlight the factors that lead to liquidation. Every student should be able to identify the types of dissolution, liquidation procedures in cooperatives. Every student should be able to describe how to appeal against dissolution, liquidation to the director of cooperative, because the director of cooperative is the liquidator. He is a liquidator of a cooperative. At least he initiates it. He can initiate the process. So that is about it. About our objective for today. Now, the process of liquidation involves activities of winding up the business of cooperative society. Liquidation comes up when a society is dormant, a society is dead, or when it can no longer meet the demands of the creditors, or when it is bankrupt. All right. The first step in the process of liquidation is for the director of cooperative to dissolve the society. This dissolution will involve the withdrawal of the society's certificate of registration. Members will, from that moment, be rendered inactive. The business of the society will come to a halt. Therefore, the liquidator will proceed with his job. Now, what are the factors that can lead to liquidation? Number one factor is starting the cooperative without a sufficient large number of well-informed members. When a cooperative society starts with a large chunk of uninformed members or illiterates, they will not know how to run the operations of the cooperative society. They will not understand the principles and methods of the cooperatives. This group of people needs a lot of cooperative education over a long period of time before they can improve. But if they refuse to acquire the necessary education and the knowledge over a certain period of time, then the society will have no option than to fold up. Illiterate members will not be able to run the cooperative business, and the end result will be failure. So that's number one reason, starting the cooperative without a sufficient large number of well-informed members. Number two, starting the cooperative society without reasonable assurance of a business turnover sufficient to carry overhead costs. Of course, cooperative has its overhead costs. If the business of the cooperative cannot handle sufficiently the overhead cost, that is a sign that the cooperative is one of the factors that the cooperative could be liquidated. When the members form a cooperative society without reasonable assurance of business turnover enough to carry overhead costs over a long period of time, the result would be the death of the society. In a similar form, if the society is involved in a business venture and the all the returns is not more than the overhead cost, that is, it's not still able to take over or handle the overhead cost. And if the situation persists for a period, the society is bound to fail. Number three factor is starting with too little capital. If a cooperative starts with too little capital, especially cash, the society is heading towards failure. Every cooperative society needs enough capital to operate. But if the members are so poor that the total capital contributed is not enough to start any tangible business, then the society will soon fail or collapse. Number four, if members are in undue haste in securing a charter, in drafting and adopting a bylaw, which will create serious handicaps and difficulties for the members of the society in the future. You get yourself will not give you the freedom to work. So if it happens that members of the society, they are just in a haste, they form the society and they are just in a haste, and that they cannot they didn't coordinate the forming or the drafting of their cooperative bylaws properly, that society is bound to fail. In addition to this, if the people adopt unsuitable bylaws, which in the end they cannot utilize to achieve their aim, you get a bylaw that is not suitable to what you are doing, you end up having a law that will cripple you, and that will make the society not to succeed. Number 5, violation of business principles. Members of cooperative society must understand that cooperative societies are business organizations, and as a result must abide by business principles if they have to be successful. In a cooperative thrift and credit society, loan must be given out to members only for productive purposes. If this is violated, the member borrowers may not be able to repay the loan. Also, in this type of cooperative society, the maximum credit limit should not be exceeded when giving loans to members. Number 6, cutting prices of goods instead of selling at market price or selling inferior goods. This is another factor that can lead to liquidation of a cooperative society. When a consumer cooperative society is in operations, for instance, they should sell their goods at current market prices and should not under any condition, in any effort to offer cheap goods, sell below market prices. Cooperatives should also not sell inferior goods, but specialize in selling quality goods. If they do this, they are likely to liquidate soon. Number 7, poor business management. The management of cooperative organization should give priority to rendering maximum services to members and should not place priority on making profit at the expense of rendering services to the members. Also, the management of the society should not run the society as if the business belongs to them. They should realize that they are running the society on behalf of the members. The secretary, the managers should not empower themselves unnecessarily. They should remember that it is to serve the interests of the members. The members should employ competent hands to run the affairs of the society. They should not employ an employee on social considerations like giving job to an unqualified person who is a relative of one of the members. That is a remedy for liquidation. Number 8, lack of proper control. The cooperative society should subject itself to regular inspection and checking by cooperative assistants and auditing by cooperative auditors. When this is done, the activities of these 2 personnel will check the activities of members and management of the cooperative society and will enable them get regular reward as pieces of advice, which will make the society grow. All the factors given above can lead to the dissolution and eventual liquidation of a cooperative society. Now let's talk about the types of dissolution. Number 1, we have the automatic dissolution. The Nigerian Cooperative Law, Section 38, subsection 1, states that if the membership of a cooperative society falls below 10 members, that is stipulated by the law, this can lead to automatic dissolution. An automatic dissolution can also take place if the society is given a specific duration at its onset. By the time the society has spent the number of years it is expected to spend, then automatically the life of that society comes to an end. Number 3, voluntary dissolution. If a society has achieved these objectives and serves no useful purpose for the members again, then the members will no longer be interested in the continual existence of such a society. This type of situation is referred to as voluntary dissolution. The members will be disinterested in the continual existence of the society, and the director of cooperative has to wade in to withdraw the certificate or registration of the society. other is dissolution and liquidation. So that is voluntary dissolution. The first of how a voluntary dissolution can happen. Number two way, or the second way voluntary dissolution can happen, a voluntary dissolution can also take place if two societies decide to amalgamate, join, as they come and join together. The parent society will be dissolved and their certificates of registration will be withdrawn by the director of cooperative. Number three way voluntary dissolution can happen if members have lost interest completely in the affairs of the society and they don't partake in any affairs of the society any longer. Then such a society can be categorized under those that will be involved in voluntary dissolution. The fourth way, whenever the society is experiencing recurrent losses of capital through disinvestment, unrecoverable misappropriation of funds, embezzlement, writing off of debt for one reason or the other, and if this persists for a long time, the society may be forced to a standstill and may lead to dissolution and liquidation. And number five, the members of a society or a cooperative society, after considering the situation of the society and are satisfied that the society is not in a position to recover from its problem, may at a general meeting request for dissolution. This had to be agreed upon by three-quarters of the members of the society. After that, they will now apply to the director of cooperative voluntarily to dissolve their society. Now, we also have compulsory dissolution. A compulsory dissolution and eventual liquidation may take place if the society experiences the following. The first is if the cooperative society is involved in a political or religious activity in a way that causes intolerable trouble or situation. This can lead to dissolution. In a situation where there is a political or religious turbulence taking place within the members to an extent that it becomes impossible for members to work together any longer, then the director of cooperative can order the dissolution and liquidation of such a society. This dissolution can take place if proper functioning of this of the cooperative becomes impossible. This is another way a compulsory dissolution can happen. If the proper functioning of the cooperative society becomes impossible, such situation can arise if there is a gross violation of cooperative laws, principles of cooperation and bylaws of the society in such a way it ruins the society. A compulsory dissolution can happen at this point. Another way is a society that can no longer meet the demands of its creditors, they are heavily indebted and cannot meet their liabilities. And the creditors may call for liquidation of such cooperative society. This can be achieved if they can convince the director of cooperative to order the liquidation of the society. So you see, another way compulsory dissolution can happen is if the creditors can ask for it. Another way compulsory dissolution can happen is the result of an inquiry. When there's an inquiry into a cooperative society and the result of such an inquiry instituted on such a cooperative by the director of cooperative may force the director to order the dissolution and liquidation of such a society. The director can order the dissolution and liquidation of the inquiry in favor of the society, because the inquiry may have recommended such a outcome. In this case, the director will make an order in writing to the society for its cancellation. Now, when such dissolution happens, there is what we call appeal against such dissolution and liquidation. Except where a member of a cooperative society voluntarily asks for dissolution, or where members of a cooperative society voluntarily ask for dissolution and liquidation. Whenever the director of cooperative writes a society to inform the members of an impending dissolution and liquidation of their society, the members have the right to appeal to the minister at the federal level, and if it's in the state level, to the commissioner within 2 months from the date the order is made. If an appeal is made, the order of the director will not take effect until the minister or commissioner gives approval or disapproval for the dissolution and liquidation. If an appeal by the members is not made within the 2 months of which the director had given order for dissolution, the order of the director shall take effect at the expiration of the 2 months. Now, the director of cooperative as the liquidator for cooperative. Let's discuss this a bit. The director of cooperative is the liquidator of cooperatives. The cooperative law gives this power to him. However, he has power to delegate this power to one of his subordinates. One of such people is the area officer or the cooperative assistant who can appoint a liquidator. Whenever someone is appointed a liquidator, he's normally given a letter of appointment, which will state his terms of references. Before the liquidator starts his job, the director of cooperative will cancel the certificate of registration of the society. As a result of the cancellation of the certificate, the society ceases as from that moment to exist as a corporate body from the date on which the order takes effect. This date is normally referred to as the date of dissolution. Now, let's highlight the activities of the liquidator after his appointment. The liquidator is appointed, or the liquidator appointed must subject himself to the guidance and control of the director of cooperatives. He must subject himself also to the limits or the limitations given to him. He would report at the premises of the society and take possession of all the assets owned by the society. Other things he would take possession of include like the books of the society, records, documents of the society, and so on. Taking into consideration what the bylaws says about that society, he would decide on the contributions to be made by present, past, or deceased members to the assets of the society. He would make a notice to the federal or state gazette, as the case may be, appointing a day on which creditors whose claims are not yet recorded in the books and records have to make their claims. If not, their claims may be excluded from the claims accrued to creditors as a result of liquidation. Now, the liquidator has to carry on the business of the society. This is only for the purpose of winding the society up. In a cooperative thrift and credit society, for example, he should not issue out more loans to members. Within the list of creditors, the liquidator has a duty to list in order of priority the society's creditors. Any dispute that arises before and during the liquidation is to be settled by arbitration. He is also to defend and institute suits on behalf of the society. He has power to call meetings of members whenever he feels it is necessary. The notice of such meetings shall be at least 14 days. He shall schedule the distribution of society's assets as he deems fit. The distribution scheme has to be approved by the director of cooperatives. He should sum up the cost of liquidation and to name whoever would bear the cost of liquidation. Now let's look through the liquidation procedures itself. Number one, it is important to note once more that the liquidator should be a person with the knowledge of cooperative laws, principles of cooperation, and the society's bylaw. Number two, the next step for the liquidator is to open a liquidation file for the society within all the documents and wherein all the documents and correspondence in relation to the liquidation will be kept. So the opening of document is next. And number three, he should get information about the names and addresses of the cooperative officers from the cooperative assistant in charge of such a society. Number four, he should plan a visit to the society and he should inform the members of the society on the proposed visit, giving them a fortnight's notice. Number five, He should write the officers informing them of his intention to take charge of the books and records of the society and to warn them not to tamper with or allow anybody to tamper with the books and records. Number 6, few days to the annual general meeting, he should then proceed to the society's premises or liquidation venue. Take charge of the society's books, records, and documents, including the society's certificate of registration. If there is any problem in obtaining the books and records, he should inform the area officer in charge. He should also acknowledge the receipt of the books and records by giving the members received for them. Number 7, he should ascertain the names and addresses of the society's creditors, and a creditors list must be prepared. This is usually done a month after the cancellation of the society's certificate of registration. The list will be sent to the director of cooperatives, who will ensure the list is published in the official gazette. A copy of this list will be sent to the area officer in charge of the society. Number 8, the notice that is published in the official gazette should give information about the date of notice, which is usually the date the notice was sent to the director of cooperative, and the date before which the society's creditors must submit their claim for the society to the liquidator. The liquidator will call for a general meeting, giving members 2 weeks notice of the intention to hold the meeting. And number 10, at the annual general meeting, the liquidator will explain reasons for the liquidation of the members to the members. He will explain reasons for the at the annual general meeting. The liquidator will explain reasons for the liquidation to the members, and he would appeal for the cooperation of all members and officers of the society. Now, number 11, after taking possession of the books and records, you should assure them that the transactions of the society are entered into the appropriate books. You should ensure that those transactions of the society are entered into the books, and the appropriate books are that, and records. The records of those transactions should also be kept and put up to date. You should enter up to date and verify the books as follows. What should he do? He should update the transactions in the cash book and the general ledger with the aid of receipts, payments, vouchers, and passbook. He should verify cash balances as per cash book against actual cash in hand, value of stock against physical stock, bank balance against bank statements, members balance against passbook, creditors balance against any statement of account available, general ledger against personal ledger, debtors balance by inviting or interviewing debtors. Now, after all these activities I've just listed will happen, after they have happened, the liquidator will prepare an income and expenditure account. By doing this, balances of all nominal accounts as at that date should be transferred to the income and expenditure account. The balances of the account, which will be profit or loss upon the date, which should be transferred to the summary reserve fund. The liquidator should open a realization account as at that date and should be debited with the book value of all assets except cash as at date of commencement of liquidation. The expenses of the liquidation will also be debited with the account, with this account, while that of the sum realized from various assets from the cash account will be credited with the account. Now, a cash account will be maintained with the opening balance of cash in hand at commencement of liquidation. All cash paid out or received will be entered into this account. All transactions affecting savings, deposit, loans, and so on should be posted directly to the personal ledger account. Then the summaries of personal ledgers balances should be used for the trial balance of the society. The next step is to open a summary of reserve funds and so on account. This account will be credited with the balance of all reserves and similar funds account And the balances of income and expenditure, realization account mentioned above, as we have said earlier, where there are surpluses on this account, where there are losses on this account, the reserve fund account summary will be debited. The liquidator will prepare a final list of creditors, especially when the date given to the Gazette had been met. In doing this, if there is any genuine creditor whose name had not been recorded in the society's books and it has emerged, a personal account will be opened for him. This account will be credited with the amount the creditor is claiming, and the society's reserve fund account will be debited. Now, efforts should be made to realize all the society's available assets. All right, the liquidator will decide whether to call on members and past members to pay some money into the society, depending on the maximum liability of members, as the bylaws of the society states, especially where assets realized are less than the book value. He should note that in the scheme of distribution which he prepares, members' shareholding should not be in the same group with members' deposits and savings. Okay, now that is what the liquidation procedure should be like. Now let's highlight some of the preparation of liquidation report and submission of such report. At the end of the first meeting for the liquidation of the society, the liquidator will write his first report on the liquidation and submit to the director of cooperatives and the area officer in charge of the society. The registration certificate of the society and the registered bylaws should accompany this report. The report should also give information about action taken so far and the problems encountered in the process of liquidation, expenses incurred, the trial balance of the society, and the personal list of creditors. Others are personal list of debtors, request of what to do on matters like the custody of society's cash, withdrawal of monies in the society's bank account, and the realization of the society's investments. After the submission of the above of this report, this above mentioned report, monthly reports will be sent regularly to the officers mentioned above. We mentioned the director of cooperative and the area officers. Monthly reports will be sent regularly to them until the completion of the liquidation. These monthly reports should give information about developments like new creditors emerging, trial balances, transcripts of realization, and cash accounts. Now, the fund of the society, how do we dispose? What's the order of disposing claims? What's the order of disposing claim? The funds of the society, including the reserve fund, shall be applied according to the laid down priority of claims. The first claim to be met is that of the cost of liquidation. All right. The next one is meeting the society's liability, including that of the creditors. The third one is the payment of share capital to members. The payment of a dividend at the rate not exceeding 5% per annum for any period for which a disposal of profit was made is the fourth priority. After meeting all these mentioned claims, any surplus fund left shall be distributed to members in accordance with the bylaw of the society. This is usually used to promote local public utility or cooperation. It may also be used to meet the claims of the society's employees, contribution to federal, state, or local government bodies, meeting claims from non-members, and lastly, any other claim due to members. Now, preparation of scheme of distribution. The liquidator will prepare a scheme of distribution which will be sent to the director of cooperatives for approval. When this has been approved, the liquidator should carry out the distribution as laid down in the scheme of distribution without any delay. Every payment should be with the appropriate payment voucher, which should be signed by the receiver, and this should be filed. Where monies are sent through the bank, the duplicates of tellers should be kept in the file. In case money is collected by somebody authorized by the creditor to collect money on his behalf, the person should be made to sign the payment voucher, and the document with the letter of authority should be kept or well kept and filed. Now, closing the book, the society's books. After the distribution exercise, the books of the society will be closed. At this junction, the books will show the cash balance. Unclaimed money can be kept with the union to which the society is affiliated to be disbursed whenever the owners ask for it. Now, closing of liquidation. When the liquidation exercise comes to a close, a notice of closure should be published in a federal or state gazette. After this notice, no published claim against the funds of the society liquidated shall be entertained after 2 years of this notice. This brings the liquidation exercise to an end. A distribution statement shall be sent to the director of cooperative and the area or divisional officer in charge. Now, in the case of amalgamation of cooperatives, let's talk about this a bit. Amalgamation of cooperative society means the merger of two or more cooperative societies which have the same objective into one single society. In this case, one society is to transfer its assets and liability into the absorbing society. In addition, the absorbing society will retain its name. In some other cases, both society may decide to take a new name. In such circumstances, the registration certificate of both society will be cancelled and withdrawn by the director of cooperative. When amalgamation is to take place, in order to protect the interest, amalgamation needs the approval of the director of cooperative. It is also the duty of the director of cooperative, either at the federal or state level, to supervise and guide the society in the process of amalgamation. If the director of cooperative appoints someone to do the amalgamation, he would have to guide or give guidelines to the officer so appointed. Okay. Now, activities of amalgamator after appointment. Let's highlight them. Number one, the officer appointed to do the amalgamation should acquaint himself with the cooperative law, principle of cooperation, and the society's bylaws. This would assist in the ability of the officer to be able to do the job effectively. Number two, the members of the society must apply for amalgamation to the director of cooperatives. This application for amalgamation must be supported by a report on the special general meeting wherein the resolution to amalgamate had been proposed and passed. Number three, the officers should ensure that the evidence to show that enough notice as required by the bylaw of the society had been given to its members and that the meeting of the members had been summoned for no other purpose than that of amalgamation. Number four, he should note the total number of members in the society that is affected by the amalgamation. This information can be gotten. Number five, in amalgamation. Like I said, number five, in the meeting where a resolution for an amalgamation is made, 2/3 of the members present in the meeting should agree to the amalgamation. Also, the creditors of the society should agree with it. Otherwise, the creditors of the society may demand for the payment of their money owed by the society before any amalgamation can take place. Number 6, in the resolution of members, the number of votes cast in favor of the amalgamation should be well recorded. Number 7, the basis for the fusion of assets and the liabilities of the society should be spelled out. Number 8, the area of operation of the new society is to be spelled out. In addition, members who will constitute the new society should be well recorded. Number 9, some members of the society may not agree to the amalgamation. Such members should signify their intention not to be members of the new society within a period of 2 months from the receipt of the copy of the preliminary resolution of the society. Now, after the first meeting of members, the society will hold a second special general meeting on the amalgamation to confirm the resolution passed on the amalgamation in the first special general meeting. The officers doing the amalgamation must ensure that a copy of the preliminary resolution had been sent to the members of the society and the society's creditors. After all the above conditions have been met, then the amalgamation of the society can take place. The amalgamation is deemed to have taken place when in addition to the above condition, the director of cooperatives registers the new society. The registration of the new society shall operate to vest in it all the assets and liabilities of the original societies. Okay, today we have presented the process of liquidation, which involves the activities of winding up the business of a cooperative society. Therefore, there is need to understand the liquidation and dissolution, the factors that can lead to liquidation, and identify the types of dissolution and liquidation procedure in cooperatives. And we have tried to do justice to this. We also have discussed the factors and the submission of reports. Submission of reports, preparation of liquidation reports, and submission of reports, and preparation of the scheme of distribution as it concerns dissolution and liquidation. All right, thank you for joining today. I expect that everyone should be able to discuss the liquidation and dissolution process, highlight the factors that can lead to liquidation. Every student should be able to answer some of these questions by highlighting the types of dissolution and liquidation procedure in cooperatives, as well as how to do an appeal against dissolution and liquidation. All right, thank you for listening. I look forward to seeing you next time.
If you have learned from these videos, click the notification button. Please give it a thumbs up so that others can see it or will see it. Always remember to subscribe if you have not done so. Until next time, keep learning.